It's true he did 3 years of service for the people, but at the end, he didn't keep the cooperation agreement.
Well, then I think we need to turn to the question of excessive sentence, because my client now is doing 18 years.
People be anonymous.
Good afternoon, Your Honors. Jan Hoth for Appellant. For over 3 years and at great personal risk, Appellant provided fruitful cooperation. His efforts resulted in several arrests, convictions, and the removal of a lot of drugs from the street.
A part of the agreement that he made was to not be arrested on any new matters, right?
That's correct, Your Honor.
That didn't happen here, though, right?
No. After about 39 months, he was arrested for assault. He did
A violent assault
Yes, a violent assault. But on the other hand,
that caused serious injuries to the complaining witness, right?
yes, it did. But however, if you look at the assault should have been considered separately from the cooperation agreement. This man lived for over 3
I
years.
don't understand why it should be considered separately. If it violated one of the terms of the cooperation agreement, why shouldn't they be considered together?
Because he didn't violate it in terms of, he didn't steal drugs, he didn't lie about his connections, it wasn't related.
Brutally assaulted another individual.
Yes, he did.
That's what I'm not understanding.
And he was tried for that, and he was sentenced.
Okay, so
for that.
let's assume therefore that we do consider it separately. He received 8 years on the drug conviction and 10 years consecutive on the assault.
And the 8 years was the minimum
Right.
for what he pled guilty to.
But that's the very point, Your Honor. Where is the benefit out of this cooperation agreement? He pled to
8
the
years.
only
8 years.
count.
The 8
only
years.
count-
He received 8 years,
he
which was the
received it-
minimum on the drug case.
But he received those 8 years because the prosecutor refused to acknowledge 3 years of fruitful cooperation.
So he should have so there should have been something worked out where he would get 3 years credit and receive 5 years?
Well, the actual agreement called for a replead, and since
The actual agreement called for, within the discretion of the prosecutor, what would ultimately occur.
Yes, but that discretion's not unbridled. Defendants are supposed to be treated fairly and in good faith. And here you allowed him to, and I mean the prosecutor, not the court, allowed him to stay on the streets, raise his family, and risk his life day in and day out. And he did it, and he did it successfully.
So you're asking us to exercise our interest of justice abilities and reduce the sentence?
What I'm asking is that he should have been allowed to vacate the plea and replead to the A2 and get the 4 years.
Based on what? Based on what?
3 years of successful cooperation.
And is there any case or anything that states that that would be proper?
Well, what's improper about finding that the prosecutor's refusal to agree to that was an abuse of discretion? Yes, the prosecutor has a discretion, but it's not unbridled. And then when you couple...
Right, but that's a question that we're confronted with, is that was what occurred within the realm of the prosecutor's discretion.
Yes, and what I'm saying is that by holding him to the A1 felony with the minimum of 8, that was wiping out, acting like it hadn't happened.
So you disagree with the use of the prosecutor's discretion?
Absolutely.
And you're arguing that we can therefore override, I guess, the prosecutor's discretion.
Absolutely.
And so the prosecutor made a determination based upon the information that was imparted by your client over that 3-year period of time, as well as the viciousness of this assault, and made a determination that that the plea was going to be to the criminal possession of controlled substance in the first degree with 8 years. And you're saying that based upon that somehow was an abuse of discretion by the prosecutor.
The prosecutor did not base that decision on anything my client had done over the prior 3 years. They agreed.
And how do we know that?
Because they agreed that his cooperation over those 3
And
years
that's why
was
they
fruitful.
recommended the minimum sentence on that. And the fact is that he violated the cooperation agreement. It's true he did 3 years of service for the people, but at the end, he didn't keep the cooperation agreement.
Well, then I think we need to turn to the question of excessive sentence because my client now is doing 18 years.
Okay, so we'll address that on your rebuttal. Thank you. Yes.
Good afternoon, Your Honors, and may it please the Court. Julia Gorski for the people. The defendant's
Pick up on
cooperation,
the last point, on the assault, the people asked for 20 years, right?
that's correct, in recognition of the fact that defendant was lucky to not have been charged with murder. The doctor testified at trial.
Attempted murder.
At trial, the doctor testified that had he not received prompt medical assistance, he would have died from either blood loss or asphyxiation from the blood pouring down his throat as the result of the defendant literally slashing half of his face off. With respect to the cooperation, it is not to the extent that the defendant presents it as. The defendant entered this agreement in June of 2013. Based on the prosecutor's sentencing memo, he did not make any cases or seizures until the fall of 2015. So while the defense is presenting this as 3.5 years of diligent, hard, useful information, it really only supports about 9 months of productive cooperation. That ended in defendant
But
being...
he was still risking his life, right? You concede that.
That's true, yes.
Okay.
But
And that was a risk he was taking for 3 years because he was arrested with someone else, right?
correct. But that was part of the agreement that he signed up for, which also included not committing any other crimes. By committing this assault, he made himself completely useless to the special narcotics prosecutor for any
Let's
further
talk about
work.
the excessive sentence portion again, because your adversary is essentially saying that he received 18 years and that's excessive. But the truth is he received 8 years, which was the minimum for what he pled guilty to, and then he received 10 years after his after the trial, and he was found guilty. And the 10 years was not the maximum that he faced, right?
That's correct.
And those sentences were run consecutively because there was no mitigation to run them concurrently.
That's
right?
correct. And the mitigation had to relate specifically to the manner in which the defendant committed the assault. So traditional sentencing factors can't be considered. Courts look to whether or not the person was injured, whether or not the defendant displayed a use of a weapon, both of which happened here. So there was just no good reason for the court to run his sentences concurrently.
So he was convicted of the assault one. What was the max on the assault one?
I believe it was 22 years. And the minimum is 5. So the 10 years on that, given the gruesome injury that he inflicted, was wholly appropriate. Just quickly, defendant's challenge to the court's waiver colloquy is unpreserved, and there's no reason for this court to reach it in the interest of justice. Neither Peque or Suazo created new rules for jury waiver colloquies, and waiving your right to a jury trial generally does not result in a criminal conviction, so it doesn't make it any more or less likely that the defendant will be deported. And unless your honors have any other...
What could the defendant have expected had he adhered to the cooperation agreement?
So if he had,
If he didn't commit the assault?
if he didn't commit the assault, it would be based on the level of information and the results that he obtained.
It's
through
still
his
up to the
cooperation.
prosecutor, right?
That's correct, yes.
But he would have been able to replead and it would have been 4 years, right?
That's correct, but the agreement specifically stated that if you commit another crime, and again, this is all in the prosecutor's discretion, but with this specific type of crime and this injury, there was no way that the repleader was going to stay on the table. And if your honors have no further questions, I rest on the brief. Thank you.
My adversary's argument makes clear my client was sentenced to 8 years on the drug case because of the assault.
Counsel, do you want to talk about the legal sufficiency of the evidence portion of your argument?
Well, I could talk about the lack of intent because I think that goes to mitigation in terms of the
He
sentencing.
ran after the guy. He ran after the, you're saying intent? He ran after the victim.
Yes, he did, Your Honor. This is a man who'd lived for over 3 years under a cooperation agreement while driving a livery cab. I don't even pretend to understand the level of stress that that would induce. They started it, they threw a bottle at his car. I think we all.
I watched the video. I think we all watched the
I
video.
think we've all watched the video, so we know.
Counsel, it was a water bottle, and your client got out of his car. He could have kept driving because he was in a vehicle. He got out of his car and he pursued the individuals. One who you can see clearly from the video looked severely inebriated.
I'm not disagreeing. I think we've all watched the video. I think we all agree on the facts. He didn't get out of the car and immediately attack.
He also got out the car with this makeshift spatula or whatever.
Well, I think it was a spatula.
Well,
but he
most
also,
spatulas ones that I use in my kitchen are not serrated and
I know mine don't
sharpened.
look
I don't have sharpened
yeah,
spatulas.
mine don't look like that either.
I don't know what you.
But we don't know that it was sharpened.
We do, don't we?
Well, it was in his car. But the point is, he also got out of that cab with a knife. He didn't say, I'm going to kill you, I'm going to F you up, I'm going to do this. He didn't stab him with a knife. He was swinging around a spatula.
Took off half his face.
Sharpened
spatula.
which had an
I am not
astonishing
trying
effect.
to mitigate.
Well, see, that's the
end
other
result.
issue. That's the other issue, though. You talked about excessive sentence. So, what would have been the mitigation to allow a concurrent sentence?
What I'm saying is that it wasn't intentional. The swinging, I mean, yes, he hurt him and he hurt him badly, but it's not the same as taking a knife and stabbing somebody in the heart. He was swinging around a spatula for what I don't want to get into. I don't want to speculate, but the point being, could have found mitigating circumstances. What I'm saying is that when you look at this as a whole, he was sentenced to 8 years on the drug crime because of the assault. And then he was sentenced to 10 years on the assault. Whether that's an appropriate sentence for the assault, I wish we
I
could.
think that I would put it, he was sentenced to 8 years on the drug case because of the assault. He was sentenced to 8 years on the drug case because after the assault, the district attorney wasn't going to allow him to withdraw his plea. That's really what happened.
And
Because
well, as my adversary
horrible
just
the crime
argued, it
was,
was the
how horrible
nature of the
the
crime.
assault was so bad that whatever sympathy the DA may have had for him on the drug case, they weren't going to exercise it.
So it's a sentence that was dictated by the assault.
It was a sentence that was dictated by his inability to hold up his bargain of the cooperation agreement.
By sustaining an arrest. Thank you.